Okay, Fernanda, are we still on? Are we already
Recording
on?
in progress.
Okay, so good morning, Professor Dr. Hélène Ruiz Fabri. Good morning, all the professors, all the internationalists, students, researchers who are here today on the 17th winter course on international law promoted by CIDIM here in Belo Horizonte, Brazil, with the cooperation of Konrad Adenauer Stiftung. So I'm very, very glad and flattered to welcome Professor Dr. Hélène Ruiz Fabri here in Belo Horizonte, Brazil. My name is Lorena Bastianetto, and I will be moderating the panel today on the power of procedure in international adjudication. So thank you very much, Professor, for your presence. Thank you very much for being with us. I will briefly present to you, Professor. So Professor Dr. Hélène Ruiz Fabri is the director of the most prestigious research institutes in the world, Max Planck Institute, and International European and Regulatory Procedural Law in Luxembourg. Professor Dr. Hélène Ruiz Fabri was a professor and the dean of Sorbonne Law School. She was also the director of the joint Institute of Comparative Law for the Master Program in International Economic Law. Professor Dr. Hélène Ruiz Fabri also taught at the Academy of European Law and also at the Academy of International Law at The Hague. So welcome, Professor. We are very, very flattered, very pleased and happy to have you here and in our international course. And please, you have the floor.
Thank you very much for your very warm welcome to this course. I'm really happy to be with you. It's not a secret that it's not the first time that I teach in this course. But the last time it was in Belo Horizonte, so it was in a different setting, and I was really happy to be there with several wonderful colleagues, and we also had the opportunity to go at this time to Foz de Iguaçu, and so I recall it as a wonderful trip, and only good memories. I remember also a wonderful exhibition by Sebastião Salgado in Belo Horizonte at this time. So only Brazilian images in my head, and this is probably what I will miss the most today. So I'm really happy to be with you. It's always a pleasure to teach for this program. Several times I wasn't able to accept the invitation because it collided with my annual leave, and at some point you have to make some family compromises about that. But this year it is all possible, and I've decided to speak about a topic which is close to my heart, but also is almost my daily business, which is procedural law. So this is what I will do. Procedural law is the general topic of the Institute, and in the department I head at the Max Planck Institute Luxembourg for procedural law. We focus more specifically on international and dispute resolution. So we focus especially on the procedure and the procedural rules used by international courts and tribunals. The Max Planck Society sets up institutes in fields of research where groundbreaking research is still to be made in principle, and procedural law is one of these fields. And I'm used to saying that procedural law is most of the time underestimated and under-investigated. So my purpose today is to give you a flavor of the importance of procedural law so that you pay attention to these rules, which are often presented as being mere technical and neutral rules, and in fact are not. So I would like to contribute to sensitize you to, we say, the political dimension of procedural law, the margin of choice they offer, and the importance it is to handle them well. And so this is my purpose. And of course, everything I say will be subject to questions and possibly contradiction. But nevertheless, this is my goal. Just to start with, I like starting speaking of that by calling to something which is common knowledge to each of us. We all watch movies or TV series or whatever. And if you look at a TV series, you will see the police is coming and telling, we do that. And the person say, but can you do that? Oh, no, don't worry, do not be bothered. This is procedure. As if it was something, you know, very light and insignificant, purely technical, something which is taken but is not significant. So you have, you're asked to provide your DNA and your call. This is procedure, but you have to consent, and the consent is presented as a formality, whereas it's all about your own integrity. But this stake is rarely pointed out. And so it is as if procedure would have no stakes, whereas it has stakes. And in fact, people who are involved in public affairs and in private affairs as well are often very aware of the importance of procedure and of setting up well contracts to have the proper provisions. So procedure is not only a subsidiary inconvenience. And so my purpose is to show you that. And I can also take an example which is rather well known, which is the example of international conferences. And there I speak more to international lawyers. In international conferences for negotiations or whatever, when you see a delegation doing this sign, or they take their plate and they put the plate on the hand, and it's the sign point of order. And when you have a point on order, you have to stop any discussion which is ongoing to settle the point of order. And most of the time, the point of order is a procedural point. So in a way, every time you have to settle a procedural issue, you have to interrupt everything else in order to make a decision. And as long as this procedural decision is not made, you cannot proceed. When I take this example, suddenly things look a bit more serious, because if procedure may have this blocking effect, it may be that it has some importance. And it makes us realize that not respecting procedural law can result in a whole process being tainted or considered flawed, including its outcome. So such drastic consequences do not fit with the image of something which would be mundane or insignificant. So my purpose, you have understood this, to underline the importance of these stakes. And for me, the opposability is determined. Their validity is determined. It has a lot to do with procedure. So this is the first reason to pay attention. The second reason to pay attention lies in the tendency to multiply procedural obligations. It's an evolution in the making of law in general and of international law in particular. If you look at all contemporary texts, you will see that decision makers do not only settle for substantive obligations, but increasingly they combine them with mechanisms aimed at following the effective implementations of substantive obligation, and like obligation of transparency, compliance mechanisms, and so on and so forth. So this, and in fact, this tendency to multiply procedural obligations comes hand in hand with an increasing difficulty to find agreements on substantive obligations. So this is something which could be seen in environmental law, where you had during the past decades a lot of evolutions in the field of international law. It was a very innovative field in this regard, because this is where many new procedural mechanisms were imagined, in particular compliance mechanisms, and all these mechanisms which try to trigger implementation of rules which are rather soft in their content or are very ambiguous in their content or are soft. So their procedure comes as a support to obligations which are not very strong, but as an incentive to implement them nevertheless. And the third reason is to pay attention to procedure is the spread of judicial dispute settlement and the correlative diffusion of models of decision-making processes governed by the idea of due process. So none of the reasons I've pointed out so far is particularly original. They exist in all legal orders, and they have already been widely acknowledged by a lot of studies. But at the same time, procedural law as a legal field remains or tends to remain considered as subsidiary, admittedly important, but never treated as central, and rarely approached in its political dimension. And so, in my view, the consequence is that essential aspects of the functioning of legal system could remain unnoticed. So what I'm going to do is to speak to you mostly in a functionalist perspective, sometimes moving to a utilitarian perspective. And I will, of course, focus mostly on legal procedure and international adjudication. But before going specifically into this, I would like to say, as a way of introduction, to develop a bit more theoretical approach to procedure, to reflect on what it is. What is a procedure? In fact, you will realize that all your life is driven by procedures. For what even a cooking recipe can be seen as a procedure. Because why? Because the first characteristic of procedure is to be order. It's about ordering a sequence of events so that this sequence becomes a regulated process, the order in which you put the ingredients. And if we go deeper into the features of procedure, I would like to point out the main characteristic that we have to keep in mind to assess what it represents as a methodology, as a modus operandi. And what is interesting there is, to my knowledge, all people who work on procedures in general, not only on legal procedures, but in procedures in general, always refer to legal procedures as references, something which has to be taken into account because it is the place where the importance of procedures is, in fact, the most acknowledged, even if not openly acknowledged, especially in academia. The main characteristics I would like to underline for procedure. First is that procedure is not a ritual. Of course, there is a ritualistic dimension in procedure. There is this, you can say justice is like a ritual because judges enter always in the same order, they wear robes, they take oaths. So you can find a ritualistic dimension in procedure. This I don't deny. But at the same time, what I would like to underline there is that there is a strong difference between a ritual in a full sense and procedure in the sense that in a ritual, the outcome is known. When you attend a mass, the outcome is known. Procedure does not predetermine the outcome. It's not at least supposed to predetermine the outcome. And to understand this distinction I'm making between ritual and procedure, it is important to take a historical perspective and to see that the rising importance of procedure, legal procedure, is related to the emergence of positive law and the renouncement to anchor legal norms in some ultimate truth, be it religious, traditional, or metaphysical. And it is also related to the need to deal with complexity. So in a ritual, you do not have alternatives. And procedures, on the contrary, legal procedures are understood to deal with uncertainty. The outcome is not known yet, but procedure order the sequence of events which would lead to this outcome and justify this outcome or contribute to justify this outcome. And so this is a very important idea. This is what is called the openness of procedure and distinguish it from ritual. This openness is sometimes and often confused with neutrality, but in fact, procedure is not neutral. And we will see it later. I will revert to that later. Procedure is not neutral because it can contribute to shape the outcome and to orient it. But nevertheless, the openness to procedure refers to the fact that the outcome is not known. The second main characteristic of procedure to keep in mind, and which is not only in international law and international adjudication, is that procedure includes processes of negotiation, of verification, and of selection. In the sequence of events I referred to previously, you have to do all this: negotiation, verification, and selection. When you organize the deliberation of a tribunal, you organize, in fact, a process of negotiation. Even if it's never qualified as such, it is a negotiation process during which the participants have to find an agreement. Whether dissents are accepted or not do not change this reality. You also have to organize the verification of evidence and of facts. And so you have all these processes which are also to be regulated. The third main characteristic I would like to underline for procedure is that it leads to closure and determinations. What do I mean by underlining this is that procedure leads to a decision, especially in the judicial field, because contrary to other authorities, judges have something I will mention again later, which is a duty to decide. Judges have no choice. I mean, a non-liquid prohibits them from declining to decide. They have to make a decision. And procedure is a tool which accompanies them to make this decision and determination. And yet, procedure sends back to indeterminacy. At the starting, you have an indeterminate situation. It's logical. You wouldn't come before a judge if you wouldn't have an uncertainty and a certain state of indeterminacy. There is a dispute because there is disagreement about the state of the law, the state of the facts, how to apply the law to the facts. And the judge is in charge of making a choice and reducing the uncertainty which inhabits the dispute to a certainty which is written in the final decision. But the decision is only for the parties, and then this decision will take the cue of maybe a stack of various decisions, but the next decision will start in a state of indeterminacy, and there is a process in learning in this accumulation of decisions. And what remains not constant, but which is always there, is procedure. And so it can contribute to create a link between these various decisions. The last idea I would like to take on board as a guiding idea is the idea of legitimacy. What I've seen in most of my readings about procedure beyond law in general is that nevertheless people reflecting on procedure related to legitimacy or trust. These ideas are very important. And an author like Niklas Luhmann, who wrote a book on legitimation through procedure, insists particularly to the close link between procedure and trust. In this perspective, procedures serve as a reference to assess the quality of a decision or of an outcome. And procedure aims at predictability of the decision process, while the outcome, the content of the decision to be taken, remains uncertain, but the process is predictable. And in Luhmann's vision, it is very important to underline this aspect, because he considers that procedure is associated with expectations about how those who are involved in the decision process should behave. They have roles which are assigned to them in the decision-making process, and the more autonomous they are, like independent judges, for example, the stricter the role requirements are. And this is a correlation which is really important. For example, criteria such as impartiality or independence, they serve to minimize environmental influences on decision-making. And so there are role requirements for judges, and judges are expected to behave according to these requirements. So these rules both protect judges, but at the same time assign to them role requirements that they are supposed to follow. So it helps avoiding conflicts of interest of those who are involved in the decision-making process. But at the same time, these requirements restrict their possibilities of action. And for example, it is difficult for someone to participate in a procedural decision and then afterwards to mount public opposition against it. So once again, you have role requirements. And this role requirement also implies some consistency. In other words, it can seem very banal, but it's worth recalling that a judge is expected to behave like a judge. And we all have an idea what a judge could be. And if we reflect a bit, we will see that we relate this to a certain number of behaviors, and we can relate these behaviors to procedural rules. So it's all about you to make these connections. So this obligations of role consistency is important. And when you accept a role, it involves not only fulfilling all the associated behavioral expectations, but also adopting the corresponding behavioral norms. So each procedure involves a certain course of events and a certain code of conduct. And it has both a collective component, which applies to all the involved actors, but also an individual component, which is the interiorization of role-specific requirements. And so this is something which is barely pointed out, but it is, in my view, interesting. So if I focus now on legal procedure, not speaking about procedure in general, but about a legal procedure consisting in legal rules, most of which are binding, but some of them can be soft law as well. It is interesting to note that authors who have worked, you have some authors who have worked for a long time on procedural law. And for one of them was Bin Chang, who wrote a very interesting book in 1953. And in his book, working on mixed claim commissions and all these more or less forgotten tribunals of the turn of the 20th century, he noted that arbitrators at this time, because at the beginning of the 20th century, you had only arbitration yet. It was the first court was in Latin America. I know, but it didn't last. The idea was there, but it didn't last. But what is interesting in the mixed claim commissions, which function at the turn of the 20th century, is that arbitrators very often called for common sense in order to solve procedural issues. And so if you read the decisions, you will read that it's common sense, it's common wisdom, that, and you have the procedural solution. It's difficult to conceive that it could happen nowadays, that a procedural issue is solved on the basis of common sense by an international judge. I mean, this would not probably be acceptable anymore. Now we have rules, and we even have an increasing space for procedural law. This is not necessarily a sign of progress, but it's just a factual statement. So when I speak of legal procedure, I speak of the set of rules which define how decisions are made and implemented. Procedural rules are very often seen if we as what Hart called secondary rules. You probably know the distinction made by Hart between primary and secondary rules, primary rules being substantive rules, secondary rules including procedural rules. And they are secondary in the sense that they govern the putting into practice of substantive rules. So this is the importance of procedural law. In this perspective, it is central to the proper functioning of any legal system. This being said, so this is a distinction which is very common and just overlap with the distinction between substantive law and procedural law. But in practice, it's not always easy to distinguish substantive law from procedural law, especially in adjudication. And yet the distinction can be important, if only because procedural issues pop up before substantive issues most of the time, and you have to settle procedural issues before being able to proceed to the merits of a case. But many rules seem to straddle the divide between procedural law and substantive law. And depending on the circumstance, they can be seen either as substantive or procedural in nature. One easy example is the complementarity principle of the Rome Statute, which stipulates that the International Criminal Court is a court of last resort, which will step in only where national courts are unwilling or unable to address international crimes. This is a procedural principle, but at the same time, the evaluation of the unwillingness or inability of domestic courts to address international crimes involves material considerations. What is more, in adjudication, because procedure is integral to every dispute, more often than not, procedural issues become intermingled with substantive issues. And so, for example, should the jurisdictional immunity of heads of state trump over the prohibition of torture? Should the immunity of state trump over the implementation of jus cogens norms, as we saw in some cases? Another example lies in the rules of attribution in the law of responsibility. The rules of attribution can play a role to determine whether a state-owned entity, for example, has a standing before a court or can be a respondent in a case. So, and rules of attribution in the law of responsibility will also, of course, play a role on the merits, that they can already play a role at the stage of admissibility, which is essentially a procedural stage. And courts may also deem the rules that seem procedural to be of substantive importance. And so in all these cases, the way a rule is characterized is of crucial importance because it will affect the question whether it is to be treated as a preliminary objection or considered as part of the merits. So you can have important decisions in this regard. And all this suggests that it may be difficult and even at times it may be counterproductive to separate completely procedure from substance. So we have to accept as lawyers, and if you have not done it so far, I can just incite you to do it as soon as possible, because it's where we work most of the time. We have to accept that there are gray areas, that there are overlaps, and it can be more productive than not to accept that procedure and substance can overlap, and we do not have a clear-cut line between both, although they do not necessarily have the same role. And your task as lawyers in different situations might be to have clear ideas whether at some point the same role either plays a procedural role or, on the contrary, a substantive role. So, but whatever the case, it means that we also have to be attentive to the rationale of the procedural rules. A recent example, it's not that recent, but it developed recently in international adjudication, was about the amicus curiae. For a long time, you had the maybe provisions about amicus curiae in some court statutes. But it was not the case everywhere. When you have to regulate amicus curiae, when you have to know how to take them into account, when you have to reflect the extent to which they can influence the judicial outcomes, you have to also reflect by the same token on the rationale of the procedural rules regulating the acceptance or the non-acceptance of amicus curiae briefs. So, and it plays a role. It plays a role to assess the legitimacy and accountability of decision makers, and in judges in general. Accountability of judges is a growing topic, and but it's also a way of admitting that this impetus for more legitimacy and accountability of judges and of this judicial decision-making can only be properly understood against a backdrop of material value. And this is true also for procedural rules. So procedural is not only technical. In the field of justice, it is supposed to translate some value like fairness, equal treatment of parties, impartiality of the judge, adversarial debate, public hearings, which ought to guarantee a fair and acceptable result of the proceedings. So a reflection on procedural rationality is necessary, but at the same time is not completely easy. But this leads immediately to reflect on how international courts and tribunals can use procedure to enhance their power and legitimacy, and how they can use maybe procedural innovations and reform to enhance their legitimacy, but and also because we have this recent phenomenon of backlash against court, about how some procedural innovations may trigger an opposite effect of backlash and decline or questions about legitimacy. So what I will do is to give some examples of the role that procedure can play with regard to the legitimacy of international courts and tribunals. I will speak mostly about normative legitimacy, which is the fact that an institution is normatively legitimate when it fulfills certain defined standards which are set in its statute and in its mandate. I don't speak about sociological legitimacy. It's not exactly the field I intend to come here today. I will not have the time to speak about all this. In fact, if I focus on normative legitimacy, I would say that the initial capital of legitimacy that international courts and tribunals have comes from their creation and the consent of sovereign state to the delegated powers that international courts and tribunals receive in the form of the ratification or accession to their statute. So they have an initial legitimacy capital coming from their creation, but there are other factors playing a role in judicial legitimacy. You have, of course, institutional arrangements which play a role. You also have procedural related issues such as the selection of judges, how judges are selected, how non-state parties can be involved, how transparent the proceedings are. All this has an impact on the adjudicator's overall legitimacy. The judicial behavior with regard to the style of interpretation and fact-finding also has a role in terms of judicial legitimacy. Of course, it depends on the mandate of the court, and it evolves within the institutional and procedural framework, and it plays a role. Another element which plays a role, of course, for the legitimacy of international courts is their output through decisions and judgments. It's an echo of an idea I pointed out a moment ago about expected behaviors, and expectations. And the output of courts might be viewed in light of the effectiveness of the adjudicator. And in the recent years, we have heard a lot about effectiveness of international adjudication. And the issue is, what do you mean with the effectiveness of international adjudication? Do you look at the intended objectives stipulated in the mandate as agreed among the state parties upon the establishment of the court? This is one way of assessing effectiveness. But you can also assess effectiveness in terms of the actual performance of the adjudicator, particularly as regards the de facto influence of the decisions, and this de facto influence can go beyond the stated mandate. And finally, of course, we can also keep in mind that you have two dimensions to legitimacy. You have the internal dimension of legitimacy, the institutional and operational aspects of the adjudicator itself, and the external legitimacy, which focuses on the universe outside the adjudicator. So if we look at internal legitimacy, we will look at what happens inside a court, and we've had some questions about who does what inside courts. If we look at external legitimacy, we will have to consider that international courts or tribunals, in fact, have several audiences. They have several audiences, which are, of course, the parties to the case, can be states, but also private actors, depending on the nature of the adjudication and of the court or tribunal. But it can be the broad public. It can be the civil society and all the stakeholders, the parties to the statute, to the court. And it can be also other courts or tribunals. And what you find in the world of other days are the stakes of maybe cross-fertilization or cross-citation, how you can look for support to your own legitimacy by calling for the wisdom of another international courts, especially if this court is deemed to be more authoritative or more ancient, more authoritative. So, of course, in this broad frame about legitimacy, procedure is only one element. But what I would like to do in the remaining half hour that I have is to do, let's say, three things. One is to show the evolution of perception of procedure with regard to international adjudication, and show that you have had several epochs or periods or steps in the consideration of procedure, showing that it has become a more and more sensitive issues. Then I would like to show why procedure is such a powerful tool that judges can use to reinforce their power, but also their legitimacy. But then I will reach the third point of my explanation, which is that for all this reason, procedure itself has to be legitimate to be able to play a legitimizing role. So a bit of a historical perspective first, to show that the perception of procedure has evolved through time. And I think we can notice more or less 3 phases or 3 steps. It's, of course, a bit artificial. Of course, already more than 1 century ago, you had a lot of people paying a lot of attention to procedure. And if only yesterday I was reading the biography of a man who was a president of several mixed arbitral tribunals after the First World War. And these tribunals had to make their rules of procedure. And this man, Paul Morio, who was president of several mixed arbitral tribunals at the same time, insisted a lot on the need of harmonization and the need to make that the various mixed arbitral tribunals have as much as possible the same rules of procedure, because it would help a lot, including for their legitimacy, if there are a kind of standardized decision-making process. So more than 1 century ago, some people already had in mind what I explained today. But these were small circles, and you need to read this kind of biography to become aware of that. If you are not very much involved in that, what you can notice is that until some 50 years ago, there was a complete lack of interest and a quasi-denial of specificity of procedure. And so the dominant idea some 50 years ago was that international law makes no sharp distinction between substantive law and procedural law. And an author like Rosen, who has authored the very well-known books on the International Court of Justice, could say in his Law and Practice of the International Court of Justice that insofar as regular legal procedures exist for the judicial settlement of international disputes, their norms are indistinguishable in their creation as in their effect from those substantive norms through the applications of which the disputes will be settled. So for Zen, in a nutshell, there was no distinction between procedural rules and substantive rules. And another sign of the lack of interest lies in the fact that even if statutes of international courts and tribunals include a few procedural rules, in fact, they're not numerous, never numerous, even nowadays. And the establishing of most of the rules of procedure is left to the courts themselves. In other words, courts received the power to self-regulate, and this is a strong specificity of international courts and tribunals. They do their own rules of procedure. And so, and it was not... In fact, if you look at the current landscape of international courts and tribunals, you will find 2 courts which are not the author of their rules of procedure: the International Criminal Court and the Court of Justice of the European Union. And in these 2 cases, it is for 2 very different reasons. They are not the authors of their own rules of procedure. In the case of the ICC, it is because there was very strong reluctance And the idea, the precedent of the ad hoc criminal tribunals created by the Security Council was that there had been a kind of procedural instability because they were testing the ground and they were modifying their rules of procedure very often. It was a source of criticism and also, but it was also revealing the stakes of procedure. And you had, for example, but it's only one example, you had this divide between common law approach to criminal procedure and civil law approach to criminal procedure. And you had some collisions between this logic, not always easy to translate this logic at the international level because you can have some kind of inflection and an outcome which is not expected. And so at the end of the day, due to these stakes and also the political stakes not to let the International Criminal Court master its rules of procedure with the effect that it would overcome some limits that states had put in the statute, it was decided that the ICC could not make its own rules of procedure. So there is an assembly of state parties which is in charge of doing so. It doesn't mean that the ICC doesn't make part of its rules of procedure. In fact, the ICC makes a lot of rules of procedure. And but at the same time, the main rules of procedure and evidence are made by the stakeholders. In the case of the Court of Justice of the European Union, the rationale is rather different. It is to be found more in the federal vocation of this court, in which case the domestic model is dominant, and in the domestic model, it's not for the courts themselves to do their rules of procedure, but for the legislative branch. And so this is what happens at the European level. Once again, of course, the Court of Justice of the European Union has a margin of appreciation regarding rules of procedure, of course. But in terms of self-regulation, these are the courts which do not have this power. The other courts have the power of self-regulation. And in fact, with this power of self-regulation, they acquire a capacity of emancipation with regard to their creators. And they can self-attribute powers which were not envisaged by the states which created them. So this has to be taken into account. For example, the European Court of Human Rights did not have, according to its statute, the power to decide interim measures. But then it put that in its rules of procedure. And then came the issue of whether these interim measures would deem to be mandatory or would not be mandatory. After the Lagrange case before the International Court of Justice, where this issue was raised, the International Court of Justice concluded for itself and based on the interpretation of its statute that the interim measures were mandatory. But for the European Court of Human Rights, the Court of Human Rights decided to follow suit and decided that interim measures were also mandatory under the European Convention of Human Rights. But the difference between the two courts is that for the International Court of Justice, it is based on an interpretation of its statute, whereas for the European Court of Human Rights, it is based on its rules of procedure that it has done itself. So it has self-attributed the power, and then it has decided that this power had as a result mandatory measures. I'm not against that. I'm not criticizing the court. I'm just showing there the emancipatory potential of procedural rules. So not to be underestimated and belonging to the political dimension of procedure. So, of course, when states decide to let courts make their own rules of procedure, it is because it's not necessarily considered a hot issue or a technical issue, which is best left to experts such as the members of the court, or because they assume there will be a reasonable outcome. But at the same time, we can see now that through this channel, in fact, courts can emancipate themselves. Like any power, the problem is the balance in its exercise and the risks of overstepping and triggering a kind of backlash in the exercise of this power. So, but nevertheless, the power is there. But historically speaking, there was a complete denial, as I tried to show. More recently, the importance of procedural law tended to be acknowledged. And so if I jump 30 years in time and look at what authors like Lauterpacht, not Hersch, but Eliu, the son of Hersch Lauterpacht, wrote, he acknowledged in his Hague academic course, which was about litigation, that consideration of procedure does not play a prominent part in the general syllabus of international dispute settlement. But at the same time, he noticed that procedural arguments were taking increasing room in some proceedings. And he stated, which is very interesting because he was also a practitioner after his father, so there was some quite experience in the family. He noted in his course, in practical terms, no matter how many solid rules of substantive law you may know, unless you know how to make them work, your knowledge of the law cannot be fully exploited. And then he added, there can in short be no such thing as international litigation without procedural problems. Nevertheless, even with this point of view, the dominant idea remained that rules of procedure are servants, not masters. And this metaphor conveys an idea of subjection of procedure with the assumption that it should be dealt with enough flexibility in order not to impede the settlement of the disputes on the merits. And some authors also speak of adjective law. And this is typically exemplified by a dictum of the International Court of Justice in a jurisdictional judgment it took in the Bosnia-Serbia case. It was in 1995. And in this case, the ICJ observed that it was not bound to attach the same degree of importance to considerations of form that they might possess in domestic law. But in fact, I would say maybe it was the swan song of this kind of consideration, because it seems to me that we have reached now a period where there is a more autonomous consideration of procedure, and that procedure attracts more attention. I don't mean it is more important, but it attracts more attention. And in fact, it takes more room as a consequence. And so you can have several explanations for that. First explanation is the rise of the idea of due process, which pervades international adjudication. So international law, especially international human rights law, states procedural standards for domestic courts. And this provides a point of reference. I can mention as an example here the extensive case law, which was triggered by Article 6 of the European Convention of Human Rights on due process. Even if you have differences between domestic adjudication and international adjudication, even if you can show that some standards have long been existing in international adjudication, it remains true that the reaffirmation of these procedural standards in international human rights adjudication plays a role in our perception and plays a role in the slow rising of a kind of universal model of equitable procedure and due process. And so it increased the perception of procedure as a legitimizing factor. Procedure has also become more sensitive with the multiplication of international courts and tribunals. And this triggered two tendencies, one of competition and one of harmonization. And these two tendencies are not necessarily contradictory. They can coexist. But in fact, when the ICJ was almost the only court, you only had beside this arbitration, and arbitration, you know, are only ad hoc tribunals, so they do not have the same authoritative stance as the International Court of Justice. So for a long time, all what was written by Rosen, by Lothar Clark, was only about the International Court of Justice. Now that you have many international courts and tribunals, in fact, you have a possibility to compare what is done from one court to another, and it paves the way for a more critical approach. Not that the ICJ was not criticized before, but nevertheless, I mean, you have more room for critical criticisms and critical approaches. But this also creates strong incentives to look at what others do when they face a procedural issue. It can be because being backed by other courts has a legitimizing effect. And for example, it's the WTO appellate body calling for precedents of the International Court of Justice to take ground in the authority of the ICJ. It can be to borrow from an international court. It can be also to plead the existence of general principles of procedural law, or it can be also to distinguish, and through distinguishing to justify its own position. So you can have this whole range of possibilities, but now we're at the stage where comparison is especially important. So in any event, procedure has become more visible, and I don't think it can be said that procedure is only a servant. For sure, procedure is a means to an end. This, I think, I've underlined at length from the beginning of this presentation. But that it is subjected to substance is not a given. I mean, you cannot draw this conclusion from the fact that it's a means to an end. It's a very classical issue, that this relationship between means and end, and it can create never-ending dilemmas. And so keep this in mind. Do you consider that the end justify any means, or whether it's not the case? Should we accept that a procedural rule like immunity blocks the implementation of use against norms? And protects maybe, I'm not saying my opinion there, but maybe protect the integrity of the judicial function? Or do we think that jus cogens as the norms expressing values aiming at protecting the most vulnerable should be given precedence on very conservative procedural rules like the rules on immunity? In fact, that procedure is subjected to substance is not true in my view. It might very well be that it's the other way around, that substance is subjected to procedure, especially if you realize that thanks to a rule of procedure, you can completely block the implementation of a substantive rule. So at the end of the day, we have to acknowledge that procedure is a powerful tool. It's a powerful tool because, as I think I've made you feel, it is unavoidable. You cannot avoid procedure. Just like a judge cannot avoid deciding, cannot say, oh no, I don't know, I hesitate, I'm not sure there is a rule, so I don't decide. A judge cannot do that. And so, as the judge has to decide, a judge has to also implement procedure and make procedural decisions. And you know the old wisdom according to which justice must not only be done, but must be seen to be done. And when you focus on this seen to be done, then you find procedure, of course. And procedural rules reveal a lot with regard to the social group where they are developed, and they provide a matrix. So Judges have a duty to decide, including to make a lot of procedural decisions, which most of the time are interlocutory decisions, which will influence the fate, but also the orientation of the whole proceedings. So keep this in mind, whether you go this way or this way will be decided through procedural decisions. And so once again, it makes even more important who decides the procedural rules. And as there is a lot of indeterminacy, it means that judges have a lot of discretion, and discretion means powers. It means power. It puts at the forefront the issue of judicial lawmaking. So there, what we have to keep in mind is that through procedural means, judges can indeed shape or significantly shape substantive law and its implementation. So, to almost conclude, I would say, not completely yet, but to almost conclude, if you have followed me on my path, you see that I've reached now the issue of how you conceive the judicial function. And speaking of that, there can be at least two functions, at least. One is a private function of settling disputes between parties. But you can also have a public function of stating the law. And whereas the private function is addressed to the parties, the public function is not only addressed to the parties, even if you have the limits, of course, of res judicata. The decision is binding only to the parties, but the way the law is stated has an influence beyond the parties, and judges and courts have, as I pointed out before, several audiences. So it can also mean a multi-layered legitimacy. You have to reach beyond the parties to the case. If you look around now, if you look at the debate on the legitimacy of international courts, if you look at the debate on the backlash against international courts, if you look at the debate on the reform of international adjudication, then you can see that the public dimension of international adjudication is more and more acknowledged. And it is more and more difficult to say that settling a dispute is only an issue for the parties. In fact, what becomes more and more prevalent is that even in arbitration, which is considered as the most private of the dispute settlement means, the third interests can less and less just be waived under the argument that the dispute belongs to the parties. You have more and more visibly a role to play for third parties, be it indigenous people in investment arbitration, being private NGOs in WTO dispute settlement, or before the International Court of Justice, or before human rights courts. Although human rights courts are not necessarily the main addresses of amicus briefs, for example. It can look paradoxical, but the big stakes of amicus briefs are more before other international courts. But the place of the voice of third parties, be they states or private parties, is a new stake. It's the stake of the 21st century. And now you have this revendication of having all these voices being heard. So this has to be taken into account. And when courts decide how they will deal with amicus briefs or interventions, they deal with this issue. And think of the recent cases of Gambia versus Myanmar before the International Court of Justice. Several states have voiced their intention to intervene. Don't know yet whether it's under Article 62 or 63 of the ICJ statute, but probably as non-parties. But what it is interesting there is the fact that ordinarily under 62, a state who would like to intervene has to show an interest in the case. And until now, the threshold was very high for the court. But when a rule like the prohibition of genocide or rules against crimes against humanity are at stake, then you have the idea that you have an interest of the whole international community, and you could assume that each and every state would have an interest in the good respect of these rules. So how do you assess in this case the interest of the intervening state with regard to an erga omnes obligation? Because each jus cogens norm is also an erga omnes obligation. There, it will be interesting to see how the court reacts depending on the number of interventions. So far, we have had mostly discourses about intention to intervene. But this will be a very interesting laboratory to see what happens and whether a kind of actio popularis logic will be populating these procedural issues such as intervention or amicus brief. What you can understand through these examples is that procedure itself can be subject to a policy because the judge can take into account the social environment. And an answer which was acceptable in the 60s, that the disputes was the thing of the parties, belonged to them, and therefore intervention was, except in exceptional case, not acceptable and easily rebuttable. In the years 2020s, it becomes far more difficult to make such an answer because it would not be socially accepted. And it means that the way you interpret procedural rules is also widely influenced by this social context, and it has to be taken into account. So I hope I show through this means that defining, but also interpreting and implementing procedural rules is a power, of course, but is also a burden because you can be held accountable with the way you implement these rules. If you have a lot of power, you also have a responsibility. And at the end of the day, there you realize that whereas procedure can play an important role to legitimize what international courts and tribunals do, as a counterpart, procedure itself has to be legitimate. It's not only a power, it's also a burden and a responsibility. And in the context, nowadays context, it becomes more and more difficult because you have such revendications as transparency, and that you see regarding, for example, WTO dispute settlement or investment arbitration. And you have a fine balance to find there to satisfy as many interests as possible while going on doing the work, which is expecting, which is delivering a decision regarding a case. And so, but at the same time, procedure carry values, and these values evolve through time, and the social environment doesn't show the same sensitivity to the same values at any period in time. And judges also have to take this into account. And so you can have infinite variation in procedural rules, but at the same time, I would say that courts have to be sensitive to the expectation of the social environment. And I would say in the world of nowadays, which has become far more contentious in its general mindset that it was 20 years ago, I think it's less easy to be a judge now than it was 20 years ago and even 50 years ago. Or at least it has become more complex. And so the capacity of anticipation by reflecting on these issues is very important. And this is why, to go back to the beginning, I think it's very important to be fully aware of the importance of procedural rules. Thank you very much for your attention. And of course, I'm now open to all your questions or comments and contradiction, because I don't ask that people necessarily agree with all what I say. But on the contrary, I hope that maybe you have some criticism or reaction. Thank you very much for your attention.
Thank you very much, Professor Hélène Ruiz Fabri. It was a pleasure, and I was very, very glad to listen to you talk about procedure, because here in Brazil, we also fight and discuss a lot about the importance of procedure. Procedure has been regarded here, especially by our schools in our state here in Minas Gerais, by a plexus of rights. So we have been talking a lot constitutional procedural rules, conventional procedural rules, so the importance of elevating procedure each day more, and the importance that procedure has acquired throughout the years, even more important than the substantive rules nowadays. So here, with those who devote to procedural law here in Minas Gerais, our state here in Brazil, they are very prone to this independence, completely independence of procedure. So I'd like to ask you a question, because we have a very important procedural principle in international law, which is the principle of consent. So the principle of consent gives judicial bodies, for example, of course, the competence ratione persona over those subjects of international law. But at the same time, you have talked a lot about the importance of judicial authorities, the responsibility of judicial authorities, and their responsibility for impartiality, their responsibility concerning accountability. So what is this balance between consent, when states give consent to be subjected to judicial authorities on the international level, they want some representation. They want some bias, even if it's implicit, but they want representation on the bench. And at the same time, we have this foundational feeling that talking about procedure, we need impartiality, we need independence. How do we balance those principles, Professor?
So there are many dimensions in your question, which could be understood as very broad. If I just focus on the last aspect you mentioned, which is the composition of adjudicatory bodies, and I would say that it depends on the courts. You have courts where all state parties are represented, mostly regional courts, and it's the case of European Court of Human Rights, the European Court of Justice. On these courts, you have a judge per state party. So there, you can discuss on how these people are nominated and then elected or chosen, but this is another issue. The other cases, and this is the case of the universal bodies and also of some regional courts like the Inter-American Court of Human Rights, there you have less judges than you have state parties. And you even have state parties to the convention, but not parties to the organization, but not parties to the convention, who can decide on the composition of the court, even if the court will not be able to adjudicate any case regarding these states, which can look a bit strange. I have worked on this under the angle of conflict of interest, because I would say that having a national judge, you could say there is a conflict of interest, because by definition, this judge is, even if the statute states that this person is independent and impartial, should not receive any instruction, well, whatever, you can say, yeah, but there will be inevitably a conflict of interest, because this judge will tend to defend the state. The opposite argument being that this judge will bring on the bench deep knowledge of the logic of the position of the state. So this, I've heard all this. Let's say that there is there a structural bias. Nationality is a structural bias which is accepted, currently accepted in the setting up of permanent courts. And the only counterpart which has been given is the institution of the ad hoc judge. the ad hoc judge who doesn't even have to be a national, which is paradoxical. This is interesting because no judge is supposed to defend the point of view of a state party to a dispute. But more or less, this idea remains that there should be on the bench someone able to voice a bit more the argument or to monitor more closely how the argument of one of the parties is taken into account. This is a structural bias which is known, but which is accepted in the name of the principle of consent. So I would say the ideological strengths of the principle of consent is such as a pillar of international law that the biases which can result for that are accepted. And paradoxically, for example, in investment arbitration or in you don't have this nationality issue because it's accepted from the start that there will not be a national on the bench. It can be by exception, but it is in principle by exception and with the acceptance of the other party. So it also shows that this structural bias is known, but is preferred to any breach in the consent principle. So this is the answer I can make there. So you can have then some manipulation of procedural rules. To go further than that, you had these cases before the ICJ regarding, you remember the Kosovo case, the Yugoslavia case at the end of the 90s when you had the bombing of Kosovo and you had the actions before the court, how many ad hoc judges you may have, whether parties should be joined. And there you could see how reluctant states are. And for the court like the ICJ, it's very difficult to resist this resistance of state because its jurisdiction is not compulsory. And so there you have a difference between courts which have compulsory jurisdiction and courts which do not have compulsory jurisdiction. So, but when states are decided to dismiss a tribunal, even a tribunal with compulsory jurisdiction because they are not happy with the leeway that this court has taken, they destroy it. This is what happened to the appellate body of the WTO, and this is also what happened to the tribunal of the South African community. And so you have to be cautious there. I don't know whether it answers your question.
Yes, Professor, thank you very much. And we have been talking about several topics here during your presentation concerning the openness of procedure, concerning uncertainty, concerning still even implicit in your presentation, but the diversity there is concerning procedure, even in self-contained regimes on the international level or in domestic level. So there is a great diversity in procedural rules. But now we have been seeing an opposite movement, a pressuring movement that to homogenize procedural rules, especially in the European Union. We have been seeing this movement towards, making more harmonized the rules of procedures for the domestic jurisdictions and for the ways judges act, the way judges decide, the way, in the end of the day, the population will benefit from the analysis of the merits. So what do you think? Do you think, for example, the preliminary rulings in Article 267 of the Treaty of the Functioning of the European Union, it's a great way it's the most effective way to harmonize procedural rules? Or do you think that it prolongs procedure and probably precludes the population from, getting the merits analyzed? What do you think about preliminary rulings?
Oh, regarding the European Union, rulings has always played a very, very important role and has played, and this is why, in a way, the advisory opinion for the European Court of Human Rights, what happens now with Protocol 16 resembles very closely to a preliminary ruling, because it's really getting advisory opinion about interpretation of the European Convention of Human Rights. So it's a very useful tool for harmonization. And for a court, it's even more comfortable to receive a request for a preliminary ruling than a full case, because it doesn't have to embark on facts and on evidence. It's only a legal answer, So I think in this regard, it's a very efficient tool. So in the case of the European Union, but it is also because you have a very strong project of unification or harmonization. You have a political project there. The issue is that at the global level, you don't have such political project. So can you use the same kind of tool when you do not have the political project backing the tool, but also justifying its use? You may remember that in the end of the 90s, when there was this big debate about the fragmentation of international law and the risk resulting for the multiplication of international courts. And it was interesting that at this time it was a question of proliferation, which is negatively connotated. This is interesting. And at this time, the International Court of Justice, the president of the ICJ, in the annual report to the General Assembly, proposed that maybe there is a reflection to have some kind of preliminary ruling by all these international courts of tribunals before the International Court of Justice. You had this kind of discussion. It didn't go very far, and at this time nobody was really ready to renounce its or her autonomy. But that was interesting that the idea was proposed at the global level, and so. But you have the whole context to take into account for what is your objective.
Thank you. Thank you very much. I have so many questions, but now I will give the floor to a student who asked here from YouTube. So Mr. Mauricio Flores asked, Professor Hélène, do you see procedure in international adjudication as necessarily linked with the Western rule of law tradition? Could we think it from other legal traditions?
Yeah, I guess we can think it. I've spoken mostly about adjudication, and I reckon that the models which are mostly referred when you speak about adjudication are the common law and the civil law model, which of course are European models, but at the same time have been widely exported through colonization. So I'm aware of that, and I'm aware that there are other models of settling disputes. What I think is interesting nowadays is the development of what are called ADR, or alternative dispute resolution mechanisms, or including online, and the increasing room for mediation and these other means. They are also rising in international law. So, so I think there is room for other ways of approaching the issue of settling disputes. But indeed, for now, adjudication at the international level is really modeled on what came from both the civil law tradition and the common law tradition from Europe. It remains a Eurocentric model. It doesn't mean that it's a fate that it remains so forever. It's just that it's dominant for now. I don't know to what extent I answer the question. Personally, I remain open to other possibilities. Doesn't mean that I'm able to imagine them. But when you work on transitional justice, especially, you see that it's absolutely necessary to consider other forms of justice that are going before a tribunal, because it doesn't solve the issues which are at stake in this kind of processes. So we have to explore further. And you have many types of justice, whether you will have restorative justice or punitive justice. And so you have to know which justice you want to serve with your means of dispute settlement. And once again, it's about the project you want to serve.
Thank you very much. And taking advantage, Professor, of the Mr. Flores' question, I do believe that procedural rules right now, they of course, they are conventional because we have several rules of the court pertaining international adjudication, judicial bodies. But from your saying, Professor, from your presentation, I could also perceive what I clearly see from case law studies, that we have a theory of precedence. Regarding procedure. So despite, for example, in the ICJ statute, we have Article 59 saying that decisions are binding only for the parties. There is a great discussion in every case law concerning procedure. So do you believe, Professor, there is a theory of precedence regarding procedure in international law?
You know, I did my PhD on international customary law, so precedent has been with me for quite a long time. It depends what you call a theory of precedent, and I think that the current debates on this issue is completely blurred with the confusion, in my view. In fact, precedents, they exist, and they exist in all systems, be it common law or civil law. It's you can speak of the rule of precedent in common law, where you will speak of jurisprudence or jurisprudence constante in civil law systems. So there are more parallels to be done than what could think at first glance. In international adjudication, the main stake is whether you have not theory precedent, because precedents indeed are used. It's part of the game you build on precedent and on distinguishing with precedent. It's a kind of dialectical game. So, and the theory precedent is never completely binding, because one of the rules of the theory of precedent is you can distinguish. So. But one of the discussion in international law is about stare decisis or stare decisis, the theory of binding precedent, which is slightly different from a theory of precedent. And so saying that you have binding precedent is one thing, saying that you have precedent is another, in my view, and people should clarify what they are talking about. That you have precedents, I'm fully convinced. Maybe it doesn't bear the same name in civil law and in common law, but it plays a role. Whether you have binding precedent, which binds you to justify why you don't apply the same solution than in a precedent, is another thing. So far in international adjudication, you do not have binding precedents. Stare decisis has always been rebutted in all cases. But that you have precedents, my answer is yes. And it's more and more visible through the multiple citations and cross citations of international courts and tribunals. So I don't know whether it answers your question, at least to a certain extent. That my answer would be yes, especially regarding procedural issues. But not to confuse theory of precedent and stare decisis of binding precedent. And in many cases, I find that the debates mix both. And therefore, yeah, the discussion becomes biased, in my view.
Sure. Thank you. I'd like to ask any of the students here at the post-graduation in international law if they want to orally make a question to Professor Hélène Ruiz Fabri. So, Professor, for us to finish, I would like to ask you, what do you think about lis pendens in procedural international law? Do you think, you talked a lot about cross-fertilization, do you think that lis pendens contributes for this cross-fertilization, for the dialogue between judicial bodies, or lis pendens contribute to, contradictory findings and rulings by judicial bodies?
You can have both, by the way. It really depends. And you have another factor that you have not quoted in this regard, that this is the strategic litigation by parties. And so when you have parties bringing almost the same case in various settings. So strategic litigation has to be taken into account. It also plays an important role. Not everything is on the shoulders of international courts and tribunals in this regard. So the issue of forum shopping and strategic litigations by the parties to create a pressure, maybe to settle the dispute completely outside through negotiations or mediation. It also happens. So like any procedural tool, lis pendens, just like res judicata or forum shopping or this, as such as a tool, it can go both ways. It can have two sides and produce good or bad effects. It depends on what you do with them. But maybe it gives me an occasion to insist again on what I said. Behind implementation of procedural rules, you have political choices which are made by tribunals. And so going for that and the way you use lis pendens, it tells something.
Professor, thank you. Thank you very much for being with us here in Sejin and the 17th winter course on international law. We are very, very pleased. I would have more 10, 15 questions to you and to continue our dialogue. I'm really, really flattered, really happy to receive you here in Belo Horizonte, and I hope you can return here presently next year and the years to come to talk about procedure. Thank you very much. I appreciate a lot and hope to see you soon. Thank you very much. And I leave you with the last considerations for closing our session.
It's my turn to thank all of you. I guess you have felt I like the topic, and so I could speak at length about it, but I'm also aware it's a difficult one. So I thank very much the people who attended this session. I hope they learned something, and it gave them the desire to go further in that. My main frustration is that I could see very few of the people attending, but I hope they enjoyed it, and I wish you all the best for the rest of this session of the winter course. Thank you very much, and have a nice day, all of you.
Thank you, Professor. It was a pleasure. We are very flattered and honored, and we hope to continue this conversation and dialogue for future opportunities. Thank you very much. Thank you all professors, researchers, students here present and accompanying us through YouTube. Thank you very much to Sejin. Thank you very much to Konrad Adenauer Stiftung. So I close right now our closing panel of the week of the 17th winter course on international law. Thank you very much, Professor.
Bye-bye.
Bye-bye.
Thank you, Professor.